Good morning, good evening. This is the USMLE Sarthi team live on YouTube. And today we have a very special guest, Mr. Douglas Carman. He is an attorney.
Good morning, good evening.
He is an immigration attorney, and he's been helping our team of students at USMLE Sarthi. In fact, he has more than 15 years of experience helping with the physicians, with their green card processes, and he knows quite a bit of this journey. And especially this session becomes relevant today as there are visa issues because of COVID situation. Students are not able to get B1, B2 visas for their electives. And then, of course, as you get to the end of the residency season, there are always questions: which visa, if you have the option to pick, should we get for the H1 versus J1 for residency? Are there other visa options? So on and so forth. So with that, let me welcome Doug. Doug, welcome, and we are glad to have you.
Thank you. And hello to everyone out there whom I can't see, but I understand that you're all physicians in training who are interested in coming to the United States and study and perhaps work. And we appreciate that, and I'm glad to see that. Of course, the United States needs new, young, and fresh talent in the medical field. And my experience with international medical graduates has been that you're all very, very talented and hardworking people. So I'd like to give you some advice about how to get visas to come to the United States, and then if in the future you intend to continue working here, path to the green card. As an immigration lawyer, my main focus on a daily basis is with people who are already here doing their training, or who finish their training and are on the path to the green card. But I also do a lot of consultation of people who are still in the beginning stages. So I got a list of questions from you, and I've organized them into two basic categories. The first one is questions about what to do before and during your residency, and the second category is the possible path to the green card after your residency. So I'll be going through those in order. I hope to give you some detail about these things that you may not be aware of. And at the end, if you have any questions about what I said, we can go over that.
Yes,
and also,
sorry to interrupt. So we are live streaming on YouTube. So any questions, if you type on our YouTube channel, I'll be able to see that, and then I'll convey it to Doug.
Okay, great. And one more thing. So this is all sort of general information for you to use in making your own individual personal decisions. And anything I say should not be construed as specific advice about what you should do in your situation, because every person has a different set of background, different set of facts, different family situations that you have to take into consideration. So so you should take that into account when you listen to the answers of these questions.
Yep.
The most common one that I get is what is the difference between the H1B and the J1, and what are the pros and cons when you're doing a residency. So first, I should say that if you are in a situation where you actually have a choice, you should feel lucky because most programs typically sponsor people only for J1 visas. And that has some limitations, which I'll talk about. But if you do have a choice, there are still some pros and cons that you want to think about. For the H1B, the pros, the main advantage of an H1B is that you can come to the United States and do your residency, and when you're done, you can immediately pursue the green card without having to return to your home country for 2 years or obtain a waiver of that requirement. Obviously, that's a big advantage. The disadvantage to there's a couple disadvantages to H1B. One is that you're limited to 6 years in H1B status in a row, right? If you reach 6 years, then you have to return to your home country for a year before you can get another H1B. For some people who want to do, fellowships after their training, and want to get in, a lot of advanced training to really specialize, 6 years is not enough for them. So they would opt for the J1. Another disadvantage of H1B is that if you have a family, your spouse would be eligible for H4 visa to come with you, but your spouse would not be able to work during that time. You cannot get a work permit for an H4. There's a common misunderstanding that there is something called an H4 EAD that's available to everyone, but that is actually an EAD that is only for special cases for people after their training who have a spouse and they've applied for immigration, but they're still in line. Their priority date is not available, and they're still in line to get the green card for several years, and their spouse will be able to get an EAD while they're waiting. But that is a very specialized situation, not really relevant to you or anyone in training, and your spouses will not be able to get EAD. So that's a disadvantage. The J1, your spouse would come on a J2, and a J2 visa holder is eligible to apply for an EAD. So your spouse would be able to work while you're doing your training.
So, Doug, a question here on J2. So what you're saying, as soon as the J1 approval is there, or the person gets his J1 or her J1, the spouse, if approved for J2, does not need any other work authorization. The J2 visa itself is a work visa.
So thanks for asking that, so I could clarify. When your spouse enters the U.S. with a J2, they are not eligible to work just because they're in J2 status. They have to make a separate application for an EAD. Unfortunately, the EAD applications these days at the USCIS can take several months. So, and that will be relevant to another question, later on about doing training in J2 EAD.
Okay.
It's problematic because of the processing delays at the USCIS. So I guess why don't I address that right now? So people also ask, can we do residency on an H4 EAD? Can we do it on a J2 EAD? So as I mentioned before, the H4 EAD is something a lot of people think is something that you can just get when you come to the U.S. for the first time, and you an H4, you just apply for EAD. That is not correct. This is a special EAD for spouses of people who have an approved I-140, which is an immigrant petition, but they're not allowed to use that approved immigrant petition to get a green card yet because they are from a country where there is a long line of people waiting in the EB2 category, and that would be India and China.
Mm-hmm.
So if your spouse who's an H1B gets an I-140 immigration petition approved in the EB2 category, and you are from India or China, you and your spouse will have to wait several years to actually apply for the actual green card. During those several years, your spouse in H4 will be able to apply for an EAD. So if you're in that situation, then yes, you can do, like if you are already in the United States and your spouse has already been working and gotten the immigration petition approved and you're in H4 status and you have an EAD, yes, your spouse can do residency in EAD with the EAD, but that is not going to be relevant to most of you who are like coming here for the first time with your spouses.
So just to clarify on this H4 EAD and J2 EAD, they can, if they qualify, if the applicants qualify for H4 EAD and or J2 EAD, they can actually do residency on those EADs. Of course, they'll have to renew it, and it is linked to the primary, the spouse who has the H1 or J1. So as long as that one is current and valid and you get to renew it every year, you can do a residency on these EADs, H4 and J2.
Yes, you can. And the J2 EAD, you will be able, if you are a couple newly entering the United States, the J2 spouse is able to apply for the EAD as soon as they enter the US. Obviously, they will not be able to start their residency the same day you start yours, because your J1 will come, they're ready to do their training, but you're going to have to wait months to get your EAD. Maybe you can start, the next year, but of course, you will be linked, and once your spouse is not in J1 anymore, you're not in J2, and you would have to terminate your work and training, even if you haven't finished it yet, unless you get your own J1.
Okay.
So that's a common question, and related question. Someone asked about what other things an person in H4 can do, like can a person do an observership in H4? Now, the answer to that question is yes, right? If you're already here on an H4, the USCIS allows you to do, it allows you to enroll in classes if you want, and do an observership, but you cannot apply for an H4, at the consulate, with the intent of, coming to the US to do an observership, because, the purpose of the H4 is just, for you to accompany your spouse. So
So H4 cannot be used to apply at the consulate for your clerkships and rotations. So I think now let's, because I'm seeing a lot of questions as well, for those who are just coming here for clerkships or rotations, what are the visas they should apply for, B1, B2, and or others? I don't know. And that's first question. And, the burning question is, now with the consulates closed and all that, what is the recommendation? So let's, hear your perspective on the visas for clerkships, rotations, electives.
Right. So for, clerkships, rotations, observerships. The standard, visa is the B1 visa. Often people will apply for the B1 and B2 in conjunction, and that allows you, to do other things while you're here, like visit family or for any tourism purposes. And typically, people just get a combination B1, B2. But the actual category that is allocated for doing things like observerships is a B1.
I see.
So so if you're the fact that you may be able to do an observership in H4 while you're here is not really relevant when you're applying for the visa. So really the only route is the B1.
I see. Okay.
So, and the burning question that you have, I regret to say, is kind of related to all the burning questions that I get almost on a daily basis about consular delays and visa problems because of COVID. And this is just one of those areas where I'm afraid I don't have any answers because of the unpredictability of this pandemic, and even worse, the unpredictability of the government agencies' reaction to the pandemic. People have inquired about asking for an emergency appointment to get a visa.
Mm-hmm.
Now that is there's nothing stopping you from making a request for an emergency appointment. Unfortunately, those emergency appointments are frequently denied, and this is for people. I have clients who have been working in the United States for years, and they for example, they have the O1 visa, and they travel back to their home country to visit family, and they want to get a new visa to come back, and they have a a full-time attending position in the United States, and they ask for an emergency visa appointment, and they get denied, and they have to wait a few months. They get stuck. So it's I mean, obviously you would think it would be common sense that the government would coordinate and think, well, they're doctors, we need them to come back, but there's not a lot of coordination and not a lot of consideration of people's needs. So I'm afraid I don't have an answer to that.
That's okay. Let me take a couple of questions that are coming up. So one question from Joanna is, can I go from J1 research scholar to H1B for residency? So I think the person was doing a research job on J1. But the 2-year home country rule was ticked not applicable on the initial DS 2019. So if the 2 years home country rule was not ticked, was not applicable, can they switch from J1 research to H1B?
Right. So that is a complicated question because so if you are actually not subject to the foreign residence requirement,
okay,
then absolutely yes, you can go from J1 to H1B. However, they often make mistakes or don't check things on the DS 2019. Also on the visa, sometimes they put on the visa stamp, you are subject to 212E when you're actually not.
I see.
And sometimes they don't at all. So you would have to, either consult with the program that offered you the J1 spot, or an attorney to determine whether or not you're actually subject.
Okay, thank you. Next question coming from Coco saying, does applying for J1 or H1B cancel out a previous application in the system if I applied for F2B and waiting for a priority date?
Not necessarily.
I see.
Not necessarily. But if you apply for J1 and get it, then obviously you would come to the U.S. and enter, and you would not need the other visa.
Okay. Yeah. Okay. Okay. So now, can we talk a bit about J1 and the waiver jobs, or I think you were about to switch to the green card questions anyway after residency. So if we can talk a bit about that.
Sure. So so most people come on J1, and near the end of the training, if you're considering staying in the U.S. And working and going the path to the green card, there's a couple options for you. The most common option is to apply for what is commonly called a waiver job, and that is to work in an underserved area for 3 years, and at the end of those 3 years, then you're eligible to pursue a green card. People who do this will typically start looking for a job in the year before they finish their training, and they'll typically, find a job in the summer, at least, before, spring or summer, before, in the year before the end of their training, and then during the fall of that year before the end of their training. This is for people who are finishing in June. This is usually the case. Their employer will submit an application for them for a waiver job, and you would transition to H1B on the day that you begin working, at the end of your training the next year. And your spouse, if you have a spouse, would transition to H4. And as we spoke before, they would lose their EAD, and they would not be able to work anymore, and they would be your dependent while you're working in the underserved area. Okay. So that's the main option. And then another option, for some people, some people, they come with their spouse, and they are here in training for several years, and during that time, they have a U.S. citizen child or two, or sometimes more. And in some cases, you are eligible to apply for what is called a hardship waiver. And if you make an application for a hardship waiver, this is where you have to demonstrate to the USCIS that your U.S. citizen child would experience exceptional hardship if you were to return to your home country for 2 years.
I see.
And I mentioned children. Also, some people come and they're single, and during the time that they're studying, they meet another resident who's a U.S. citizen. They fall in love. They get married. And also, if you have a U.S. citizen spouse, you can apply for a hardship waiver. Now, I actually specialize in hardship waivers. So I just wanted to say, at the outset, that hardship waiver is, difficult to get, and approved, only for people with quite unique circumstances. So I would not recommend making any family planning decisions, based on applying for a hardship waiver, because to demonstrate exceptional hardship, you have to show that the hardship to your U.S. citizen spouse or child would be unique and different than uh, the normal hardship any other person in the same situation would experience. And that usually involves, like, if the child has medical issues, or if the spouse can't work, or things like that. So that's those are the two ways. There's also a persecution waiver if you come from a country that is undergoing civil unrest, and if you feel like you would be persecuted on the basis of your race, religion, political opinion, or nationality. It's kind of like an asylum argument, but in a different context. That's also available. That's kind of rare, but it's also an option. So after you either work for 3 years in an underserved area, or get a waiver based on hardship or persecution, then you have the opportunity to pursue a green card, and there's two ways to do that. One is by having your employer sponsor you, and so if you are happy with your employer and they're willing to sponsor you for a green card, then they will begin the process for you. And this is something basically you just discuss with them, and then they would do it for you. You don't need to make the application yourself or hire an attorney. This is something your employer would do for you. In essence, they would advertise for your position, and if no qualified U.S. citizen or green card holding worker applies for that position, then they move on to the next step, and as long as they demonstrate they're paying you, at least the average wage, and that they have the ability to continue paying you, then they sponsor you and follow through for the green card. And that process can take a year and a half to 2 years, during which you would need to stay with that employer, because they're the ones sponsoring your case.
Okay.
So the other option is what's called a self-petition. And there's two different categories for that. There's the EB1 and the EB2 NIW. And these are the argument in the process of application is quite similar. You hire an attorney to put together an application for you that shows that your work is unique and extraordinary in some way, or it's in the national interest that you don't go through that whole labor certification process that I described in the employer-sponsored application. So that is an option that gives you a little more independence and sort of a faster track to the green card, and allows you to change jobs if necessary, during shortly after the process. Those cases are for people who there's a lot of different criteria that they look at. One of the main criteria they look at is your research record. So if you have already done some research, or you've done significant amount of research during your period of training, you might be a good candidate for that. But that's not the only qualification. They also look at other things like leadership skills, and whether or not you're involved in reviewing the work of your peers, awards that you've received, and things like that. So that is an option available for people who want to go through more quickly.
Okay. Okay. One question which is coming up is, can we convert if we are on B1, B2 here? Can we convert it to J1 if we get through residency, or do we have to go to the home country?
You would, I mean, technically speaking, there is a process available for changing from visitor visa to a J1, but practically speaking, because of the USCIS processing times, you will need to leave the country with the DS 2019 from your institution and get a J1 visa and come back.
Okay. And if one gets married while one is on J1 and working in the underserved area for the 2-year waiver home country rule, can the spouse file at that point for green card? I would think the answer is no. What is the answer?
Right. Yes, the answer is no. So, if you get married while you're to a U.S. citizen while you're on J1, um, you might be able to apply for a hardship waiver first. It allows you to waive the foreign residence requirement. Um, and if you get an approval of that hardship waiver, then your spouse can sponsor you for a green card. So you'd have to go through 2 processes, and the first one being proving to the USCIS that your spouse would experience some kind of unique hardship that is different than the normal hardship a typical spouse would experience being separated for 2 years.
Okay. And are there any specific requirements for J1? I mean, once the program says, okay, we'll give you residency on J1. So the question which is coming up is, what are the specific requirements?
Well, I mean, for the visa itself,
For the visa.
I mean, the main requirement is that you demonstrate to the consular officer, during the interview that you intend to pursue this training and then return to your home country at the end, for at least 2 years. And, sometimes the officer will, pressure you and, ask a lot of questions in order to convince himself that you will actually do this. So, it helps to, put yourself in that position and, think of, what are the reasons why it's important for me to come back? Like, do my parents, depend on me, to be at home? Do I have a job offer, in my home country at the end of residency? Things like that, that show that you have the intention of returning.
Okay. And is there a typical timeline for J1 processing? Once, let's say after the match, they get approval from the program. From a consular embassy perspective, now it could vary with COVID, but what is the typical timeline?
So pre-COVID, depending on the consulate, could take a few weeks to a few months. But these days, hard to say.
Okay. Okay, so I think we already answered it, but a question is coming up. Researchers on J1 visa changing to green card based on no objection waiver from home country. How does that work?
Yeah. So if you came to the United States as a research scholar and you are subject to the foreign residence requirement because you're on the skills list, for example, um, you can ask for a no objection waiver if you ask the home country to say to send a letter to the Department of State that they do not object to you staying in the United States. However, a no objection letter. Um, so for people who come to the U.S. for clinical training through the ECFMG, you can't get a no objection letter for that. So that's a lot of people ask about that. That ECFMG training is not, you can't waive it from getting a no objection letter. But
I see.
if it's a research position and you haven't done any clinical training, you could ask your home country for that.
Okay, well, looks like those are the questions we had. So, well, thank you very much, Doug. Appreciate your time as always. And guys, I will post his information on our YouTube channel. It's also on our website. His URL, very helpful. Our students have typically gone to him. So if you need immigration advice or anything, just set up time with them, their team, and they are very helpful. Thank you, Doug, and appreciate your time.